Ladies and gentlemen, my name is Sameer Shah, and I'm an M&A partner in Khethan's corporate M&A group. Welcome back to the second of our webinars as a part of the M&A Academy program. The M&A Academy program is designed to provide foundational legal knowledge about M&A legal issues and processes to corporate executives, in-house legal teams, and others participating or interested in M&A. We conducted our first webinar in March and received an overwhelming response with 3-digit attendees, 4-digit registrations, and almost 5-digit views on our YouTube channel. What an exceptional, encouraging, and overwhelming response to this proposition. For our YouTube viewers, we will include relevant links to the first webinar and future programs in the captions and comments below this video. Of course, M&A is an important part of our firm's practice, with more than 60 partners dedicated to this area, because India is experiencing a massive growth in M&A transactions. And speaking of partners, may I add, we are now proudly 200 partners and the first Indian law firm to do so. Our subject today is asset purchase agreements, structure and key terms. And while share purchase agreements was treated as the first topic for its obvious importance, truth be told, a share purchase agreement is in fact a specific class of asset purchase agreements. When parties decide to buy and sell assets, it is usual to record their definitive legal understanding. And while asset purchase agreements tend to have far greater variety, given the ever increasing variety to the nature of assets they can transfer, share purchase agreements are confined to shares of companies alone. Assets can vary from brick and mortar real estate to intangible assets such as telecom spectrum or customer data. And for this precise reason alone, the topic for this webinar is quite important. And while businesses as such may be conducted through a company or a partnership, one cannot always buy the entire whole. And for reasons which we will explain in more detail today, suffice to say, sometimes it is either the buyer who wants to leave something behind or the seller who, for his own business reasons, wants to retain something in his own hands. As a result, it is important for a good M&A ecosystem participant to have a good understanding of asset purchase agreements, which is, of course, our objective. In summary, we will have a formal presentation, followed by a Q&A session with audience questions. We have already received several questions through registration. Please continue to submit your questions through the webinar portal. Like our first webinar, if we again receive more questions than we can address, we will definitely respond offline over email after the webinar. We will also send the presentation, the summary notes, and a recording of this webinar to you afterwards. Moving on to introduce our speaker for today. We have with us my partner Nidhi Kilawala, who is an M&A partner based in our Delhi office, although she works on projects nationally. Nidhi has been a lifer with Khethan and will soon complete a decade of M&A experience. We circulated her profile over email to the participants, but just to mention once again that she is an M&A expert and carries tremendous recommendations in this area of work. Clients who call upon her frequently include SoftBank and Blackstone, and most recently, she was involved in the largest EdTech M&A transaction in the world, which saw her advising founders of Akash in their sale of their highly successful venture to Byju's for a whopping billion green ones. It is therefore difficult to think of a better partner to share her knowledge with you on this topic. So without further ado, I invite Nidhi to deliver her presentation.
Thank you for the kind introduction, Sameer. Good afternoon, everyone, and thank you for joining today's webinar. The presentation for today is Asset Purchase Agreements, Structure, and Key Terms. Anyone working in M&A today needs to understand how an asset purchase agreement works because, as Sameer mentioned, it allows the buyer to only purchase some of the assets of the seller and also allows the buyer to decide which liabilities it wishes to acquire, thereby giving the buyer the flexibility to leave behind those liabilities that it does not wish to accept or that it does not know about. This is clearly one great distinction of an asset purchase agreement from the previous session of our academy, where we spoke of share sale transactions. In those transactions, as we discussed, the buyer becomes the owner of the shares of that entity and therefore takes on the assets and liabilities of that entity. An asset purchase transaction will give the buyer the ability to leave behind those liabilities that it does not want. And the intent of today's presentation is to therefore provide you a high-level overview of an asset purchase agreement, its key terms, what are the fundamental elements of such a transaction, and hopefully the next time you are involved in an asset purchase transaction, this presentation and our discussion proves to be handy. In the course of the next half an hour, I will try and summarize the structure and the key terms of such a transaction. But like any structuring transaction, tax considerations prove to be meaningful even for an asset sale agreement. These will be discussed in greater detail by my colleagues in the upcoming sessions of the M&A Academy, and we will not delve into these for the scope of today's presentation. Moving on is the agenda on your screen. These are the topics we'll touch upon today in the course of the next half an hour. So without much ado, we'll get straight into it. The first question that we must address when approaching any transaction is, what is this transaction? And therefore, for us today, it's important to understand what is an asset purchase. In case of an asset purchase agreement, the buyer has the ability to cherry pick the assets and liabilities that it wishes to acquire from the seller. The key distinction again in an asset purchase from a share sale is that separate transfer has to be undertaken for each asset that the buyer wishes to purchase from the seller. We'll discuss what that means for your document, for the transaction, both from a deal cost and deal timelines perspective in the upcoming slides of this session. Price allocation will also need to be done by the buyer and the seller for each asset that is proposed to be transferred. Given that each asset is transferred separately and prices associated with that transfer, stamp duty implications also prove to be meaningful in an asset purchase agreement. We'll discuss this in greater detail in just a short while. Successor liability is also an important point and becomes a key structuring decision while discussing what is the right kind of transaction to undertake by the buyer and the seller. And important to bear in mind that for an asset purchase transaction, the buyer has to be an Indian entity. So if you are representing a group that would otherwise like to purchase assets from an Indian company but is present outside India, then the deal timeline should factor incorporation of an entity in India, because the buyer would need to be an Indian entity, unlike a share sale transaction where foreign companies can acquire shares of Indian sellers. Moving on to the next slide is an important decision and discussion to be had as to what are the key differences between a share sale and an asset sale. As you can see here, the most important point here is who you are transacting with in these transactions. In the share sale, the transaction is happening between the shareholder of the target and the buyer, where the shareholder is selling the shares of the target company to the acquirer. Compare that to an asset sale on the right side of this diagram, is that the transacting parties in an asset sale are the acquirer, which is the buyer, and the target that actually owns those assets and liabilities. The shareholders of the target therefore do not necessarily become a party to this agreement, and the transaction takes place between the target and the acquirer. And post an asset sale, the acquirer does not become a shareholder of the target, which is what would be the end result of a share sale transaction. When you look at the next slide, which includes the key distinction between the asset purchase and the share purchase, what becomes clear is that in an asset purchase, the buyer and the seller agree to the list of liabilities and assets that are to be transferred to the buyer. The buyer does not become the owner of the target company, which, as we just discussed, would be the end result in case of a share sale transaction. Buyers therefore oftentimes prefer to undertake certain transactions as asset purchase transactions, because only those liabilities which are specifically agreed to be assumed in the asset purchase agreement are deemed to have been transferred to the buyer. Any other liabilities, whether they are known or unknown, but are not specified in the asset purchase agreement as being transferred to the buyer, will continue to remain the seller's responsibility. This is one of those key reasons why oftentimes buyers would prefer this to be the mode through which they acquire the assets or business from the seller. Assets can also be purchased as an asset sale agreement or a business transfer. In case of a business transfer, there's obviously no ability available with the buyer to cherry pick the assets and liabilities. In this case, the business will have to be purchased by the buyer on a going concern basis, undertaken as a slump sale. Whether the right kind of acquisition and structure for your transaction is an asset sale versus a business transfer versus a share sale will obviously depend on the commercial reasons for which the transaction is being undertaken and what it is that the buyer wishes to acquire. But certain factors that become important to decide whether you want to undertake any of these transactions will involve discussions on deal timelines and deal costs. In case of an asset purchase, as we discussed, every asset has to be transferred separately, and therefore oftentimes this results in lengthier deal timelines to consummate that transaction. In case of a share purchase, the deal timelines are typically shorter, given that the parties have entered into a share sale agreement and then the shares are being transferred on the closing date. In case of an asset sale, however, a lot of actions will need to be undertaken as conditions precedent before which the parties can proceed to closing. Consequently, stamp duty implications also become important to understand in an asset sale agreement, where these can potentially be material and rather high. This will depend on the nature of the assets that are proposed to be transferred from the seller to the buyer. And we'll discuss this in some more detail as we get progress along in this session. Moving on to the next slide, it's the most important question one should answer at the outset of any transaction. Who are the parties to this transaction and what it is that they wish to transfer? The buyer and the seller are obvious parties to the transaction, but I think it's also important to understand who is the legal owner of the assets that the buyer wishes to acquire. As an example, if there is a large group from which assets are being purchased, then those companies may be structured in a manner where assets are owned by different entities within that group structure. So for the buyer, it becomes an important determination during its due diligence process to figure out which entity owns the assets that it wishes to acquire and accordingly add that entity as a seller to the asset purchase agreement. Oftentimes, key shareholders and promoters of the seller are also included as parties in the asset purchase agreement so that they can undertake procurement obligations and ensure that the seller performs its end of the bargain and all the steps are taken from the time the document is signed till the time it closes, and post-closing obligations are also adhered to. Once we've understood who the parties are, it becomes extremely important to identify the list and the assets that are being transferred. An asset purchase could vary. The nature of the assets to be transferred in an asset purchase could vary greatly. It could be something as simple as tables and chairs to something as large and important as a movable property, factory land, factory machinery. So it's very important that when you are setting out what it is that you wish to purchase in your asset purchase agreement, you are being as specific as possible and being as descriptive as possible. So whether it is licenses, intellectual property, equipment, contracts, employees, etc. The goal should always be for that list of assets that are being transferred to be as descriptive as possible so that you eliminate any confusion and misinformation going forward. The asset purchase agreement should also explicitly set out that the assets that are being transferred from the seller to the buyer are free of all encumbrances and that clear title is being passed on from the seller to the buyer. The agreement should specifically state that on the closing date, once the buyer becomes the owner of the assets that have been purchased from the seller, the buyer will own it with all its right, title and interest and without any encumbrances of any nature whatsoever. Moving on to the next part of our presentation is the discussion on conditions precedent and pre-closing undertakings. Asset purchase agreements usually require more formalities and documents than a share sale transaction because, as we discussed, asset purchases require transfer for each of the seller's separate assets and liabilities. The key to a successful asset sale transaction, at least from a documentation and administrative logistical purposes, is planning and pre-planning. No amount of planning is too much when we're trying to consummate an asset sale transaction. And Each piece of the puzzle will come together to eventually give you that completed jigsaw. So it's important that we ensure that along each step of the way for the conditions precedent are done in such a manner that they enable the buyer to become the owner of these assets that it has purchased on the closing date. As an example, when you are diligencing the assets that you wish to purchase as a buyer, regulatory approvals could appear as one of the conditions precedent that typically find their way into an asset purchase agreement. To give you an example, if immovable property is being transferred, then it becomes extremely important to check how that immovable property is being used by the seller today. If it has been leased from a governmental authority, then sale of this asset to the buyer may require the prior consent of such governmental authority. This may often also entail a high transfer fee to be paid to the governmental authority. So this condition precedent becomes very important both from a deal timeline and deal cost perspective, and is something that will be fleshed out as part of the diligence process. Another regulatory approval that oftentimes finds its way into an asset purchase agreement is what we call a Section 281 NOC. Under Section 281 of the Income Tax Act, if a taxpayer proposes to transfer any of its assets during the pendency of any tax proceedings, then the tax authority has the power to treat that transfer as void in order to recover the pending dues from the seller. So you can imagine for a buyer, this is really, really important, because what we're really saying is that if seller is subject to a pending tax proceeding, then the authorities could potentially treat your transfer as being void. There are therefore two exceptions to this provision which come to the rescue of the buyer. One is that the transaction should have taken place for adequate consideration and without the buyer's knowledge of those tax proceedings, or the seller has procured a Section 281 NOC from the authorities in India. So if you are in a transaction where, as part of the diligence process, you have been made aware of the pending proceedings involving the seller, then the only available exception to this provision would be for the seller to procure this 281 NOC prior to closing, so that this transfer is not challenged at a later date by the Indian tax authorities. This again becomes important to factor in at the outset itself, because this will impact deal timelines given there is a dependency on a third party. Another important condition precedent that you will often see in an asset purchase transaction are third-party consents. Again, this will depend on what kind of assets are being procured. However, if you are looking at transfer of material contracts from the seller to the buyer, then one should check if novation or assignment is possible without the consent of the counterparty to that contract. If that is not the case and consent is required for such novation or assignment, then these consents will need to be procured as conditions precedent to the transaction. Similarly, if employees are proposed to be transferred from the seller to the buyer, then consents will need to be procured from those employees as well for their transfer to the buyer entity. Sometimes if one is dealing with a lot of employees or a large number of employees who are proposed to be transferred from the seller to the buyer, then parties sometimes agree to a minimum threshold number and category of employees whose consent has to be procured as a condition precedent, with the rest to follow in due course post-closing. Special care needs to be taken in case of employees who are part of a trade union or are blue-collar employees, because they are statutorily protected in such instances of transfer. Whether the employees that you as buyer are looking to add to your roles are in fact workmen or not will be a test that will be largely factual in nature. But as a rule of thumb, it is always recommended that in case of transfer of employees, the transfer should be done on terms no less favorable than those applicable to their current employment and with continuity of service. Another important condition precedent to discuss in an asset purchase agreement is execution of ancillary documents, particularly with respect to a transition services agreement. This is essentially an agreement where the seller contracts with the buyer to provide certain services to the buyer for a specified period of time post the closing in order to allow and support the buyer to get used to its newly acquired assets. Obviously, the seller knows the assets better than the buyer does at that point in time, and therefore the seller may be well placed to provide certain services to the buyer while the buyer gets to acclimatizing itself with those assets and making it a part of its business chain. Key items to bear in mind while dealing with the transition service agreement is clearly setting out what is the scope of those transition services, what is the time period for which those services have to be provided, how will the performance and the compliance of those services be monitored, how will fees be paid, is it on a fixed basis, is it on a variable basis, if it is in fact variable, then what are the components of the parameters to decide how that variable fee is to be calculated, is there a hard stop to the agreement? As an example, if the agreement had to be for a period of 6 months only, but let's say the buyer needs some more time and support from the seller, then can that agreement be extended unilaterally by the buyer, or would that agreement have to be necessarily terminated at the end of that time period? All of these factors become important while discussing a transition services agreement, which is oftentimes a key element and a key ancillary document while negotiating the asset purchase agreement. Another important condition precedents that you would find in an asset purchase agreement is one of material adverse effect. As we discussed in the first session of the M&A Academy as well, this is also relevant in the context of a share sale transaction. Essentially, what parties contractually agree to in the document is that there is a certain condition and a certain manner in which the buyer expects to receive those assets. If there is any event that takes place between the signing and the closing of the transaction, which would change the buyer's understanding of those assets or the condition in which those assets have to be acquired by the buyer, then the buyer would like to be able to walk away from the transaction. The seller, on the other hand, may want deal certainty, and therefore they may not want to provide such broad walkaway rights to the buyer. So a material adverse effect condition precedent is quite hotly negotiated and debated at the time of the signing of the asset purchase agreement. Another key element to discuss between signing and closing is the pre-closing covenant. In an asset purchase agreement, as we have just discussed, there would be several conditions precedents that need to be completed. As a result, the time gap between signing and closing in an asset purchase agreement is oftentimes longer than a share sale deal. It's therefore important to look at this section very closely and ensure that maintenance of assets between signing and closing in the ordinary course of business and consistent with past practice is included as a condition for the seller. These conduct of business provisions usually help preserve the business in the form that is expected by the buyer and maintain it in a condition that the buyer investigated at the time of its due diligence. Access and investigation provisions also are important to include for the time period between signing and closing. It basically requires the seller to permit the buyer to access the acquired business and its books and records prior to the closing. Among other things, this enables the buyer to continue planning for and implementing its integration of the acquired business and the assets during this gap period. Exclusivity is, of course, another essential pre-closing covenant to include in this interim time period. It is to make sure that the seller is not having multiple discussions and conversations with other potential buyers for the same transaction for which you are interested in those assets, and therefore this would always find its way into an asset purchase agreement. Notification on key matters is also another important pre-closing covenant to include in the asset purchase agreement. The idea is essentially twofold, which is for the buyer to have real-time information about what it is that the buyer is purchasing, and to make sure that if there is any change to that understanding, then the buyer is made aware of that at the earliest possible. And also the second point is for the buyer to be able to declare a breach of this agreement and terminate the agreement if the buyer should choose to exercise that right. So these are the typical conditions precedent and pre-closing undertakings that you would find in an asset purchase transaction. Moving on to the next important element of an asset purchase agreement is that of closing and the manner in which the assets are actually transferred. As we discussed, in case of once all of these conditions precedent have fallen in place, it now results in the actual closing taking place, which is that the asset has to change hands from the seller to the buyer. In case of contracts, there would be assignment or novation that is taking place on the basis of the consents that were procured as conditions precedent. In the case of licenses, again, in your due diligence exercise, you will need to check what kind of licenses does the buyer need to use these assets post-closing date. Some assets are capable of being transferred, and therefore transfer applications will need to be filed with the relevant authorities. However, in cases of licenses which cannot be transferred, the buyer will need to make fresh applications on the closing date so that the buyer can legally carry out the business post the closing date. In this case, it becomes extremely important to have support and cooperation from the seller, because the seller is the entity that has had these regulatory licenses so far, and therefore it becomes very important to include a further assurances clause in your asset purchase agreement so that the buyer can rely on that clause and request the seller to reasonably cooperate with the purchaser to sign such further documents as may be required to ensure that the full commercial effect of the transaction at hand is given to the buyer. In case of employees, again, as we discussed, consents will be procured for the transfer as a condition precedent, but the actual transfer will take place on the closing date with new employment agreements being executed by the buyer with these transferred employees. In case of intellectual property, assignment agreements are often executed to make sure that title is provided to the buyer over such intellectual property that is transferred. And also transfer applications will need to be filed on the closing date with the relevant regulatory authorities in India. In case of immovable property, lease deeds or sale deeds will need to be executed depending on the ownership of that asset, and also this may need to be registered with the relevant authorities in India. This will entail a high stamp duty and a registration fee, which is often linked to the market value of the property. In case of movables, delivery notes are executed by the buyer and seller, which essentially set out that delivery was handed over of A, B, and C movable assets to the buyer, and the buyer has acknowledged receipt of those assets. Some other miscellaneous documents that are also exchanged on closing date are the corporate approvals of the buyer and the seller entity. This would be the board and the shareholder resolutions. If the seller has any specific committees in place which require them to vote in favor of such transactions, and committee approvals are also often sought on the closing date. Moving on to post-closing conditions, this is important from the perspective that the agreement does not cease to become relevant after closing, or rather at closing. There are certain ongoing obligations that both parties have even after closing has in fact occurred. One is, of course, the transition or the shared services agreement, which we discussed as part of the conditions precedent. This agreement actually kicks in only at and from closing, and therefore will govern the rights and obligations of the parties for a certain time period post the closing date. Confidentiality is a very, very important clause and is typically applicable in perpetuity. It's important to bind both the buyer and the seller to a confidentiality clause in the asset purchase agreement. The seller has alienated itself from these assets now because it has been transferred to the buyer. So the seller has very little incentive or reason to hold any of the information associated with those assets or business in utmost confidence. And therefore, such a contractual protection is extremely important for the buyer. And the last post-closing obligation that we'll discuss today is that of the further assurances clause. As we discussed as part of the closing and the conditions precedent process, the seller is the entity who is closer to the business or the assets being acquired. They have more information about the assets or the business, and therefore, as the buyer is progressing in its integration of the newly acquired business or assets with its own business, it may require certain additional support from the seller in order to ensure that the full legal effect is transferred to the buyer of the asset sale transaction. A further assurance clause therefore comes handy in such situations to ensure that the seller continues to provide that support despite closing having taken place. Moving on to the next slide, we'll be talking about critical risk allocation tools in an asset purchase agreement. As discussed in the share sale M&A session, a critical risk allocation tool in most transactions involves a representation, warranty, and indemnity package. In an asset purchase agreement, the buyer has an additional risk allocation tool, which is that of the assumed and excluded assets and liabilities. So while representations, warranties, and indemnities continue to be relevant even in an asset sale transaction, the buyer also uses this crutch, which is of assumed and excluded assets and liabilities, to ring fence its liability and clearly set out exactly what it is that it is purchasing and try to keep out any risk associated with the unknown or unwanted liabilities. As you can see on your screen here, essentially before closing, all the assets and liabilities remain with the target company. At and after closing, the acquirer entity, which is the buyer, will pay good value to the target company as purchase consideration and acquire only the assumed assets and liabilities. The excluded assets and liabilities after closing will continue to remain with the seller entity, whereas the assumed assets and liabilities will then move to the buyer entity. The reason that this is extremely important to set out in great detail in the transaction is because this is one of the key distinguishing features of an asset sale transaction. In the event you have decided as two parties to this agreement to undertake the asset purchase transaction, the likelihood is very high that it was because the parties were clear that they did not want certain assets and liabilities and only wanted to assume certain assets and liabilities. So this section of the contract becomes extremely important to draft. It will set out clearly which operational risks will reside with each party following the transaction. And in achieving that goal, it will also force the parties to think through the potential risks of the transaction and how those risks should be allocated within the agreement. If you talk about the buyer's preference with such excluded assets and liabilities, buyer will always, of course, think that liabilities of any kind increase risk. But liabilities that are not anticipated or not known can be exponentially more dangerous. And so the buyer will want language in the agreement to state that the listed liabilities are the ones that it is acquiring, and it will define the assumed liabilities as specifically as possible. The excluded liabilities, on the other hand, from a buyer preference standpoint, will be framed as a non-exhaustive list and will oftentimes state that this list will include any liability that is not specifically assumed. As an example, tax liabilities of the seller are more often than not considered to be excluded liabilities by the buyer, and any liability of the seller pre-closing date is also often treated as an excluded liability in such asset sale transactions. The seller's preference, on the other hand, is at the other end of the spectrum as compared to the buyer, which is that the seller will want the assumed liability section to be a non-exhaustive list. And they will want to say that any liability which is not specifically excluded is considered to be an assumed liability by the seller. Of course, where you end up on this list will be the subject of a lot of negotiations at that time. But this is an important risk allocation tool to bear in mind in an asset purchase transaction. In a stock sale, the liabilities of the target company automatically transfer to the buyer, and therefore in a share sale agreement, you will never find mention of assumed and excluded liabilities, and the bulk of risk allocation in a share sale transaction is achieved through representations, warranties, and indemnification provisions, which is the next part of our discussion. I won't talk about this in a lot of detail because the principles remain the same as those discussed in the last session of the Academy on share sale transactions. But just to briefly recap, representations and warranties are essentially statements that the seller will make to the buyer with respect to the business, the assets, liabilities, condition, properties, etc. And if there is an inaccurate representation or warranty, then this may result in incurrence of liability by the seller. The seller warranties in an asset sale transaction will be linked to the assets that are being acquired. while doing this exercise, it will also help force disclosures from the seller to make sure that the buyer is made aware of any representation and warranty which may not be true, and therefore the buyer will know that if there is a liability associated with a certain asset that it is acquiring and it has been disclosed in the disclosure letter, then it has had the ability to allocate a certain risk level to it. If the disclosure, of course, is so lethal that the buyer does not wish to assume such a liability, then that becomes a discussion on whether the buyer would like to, in fact, go ahead with the transaction or not. Bringing down of seller warranties is also important because, as we discussed, in an asset sale transaction, there is a substantial time gap between signing and closing date, and therefore it is extremely important for the warranties to be true, not just as of signing date, but also as of closing date. The other side of the representations and warranties is what happens if these representations and warranties that were provided by the seller do in fact turn out to be untrue, inaccurate, or if there is a breach of such representations and warranties. This results in the indemnification construct, which you will find in both asset sale agreements and share sale transactions. As you can see on the next slide, in a typical indemnification clause, you will find a survival period that is mentioned for the representations and warranties, after which claims for breach cannot be made by the buyer. There will be indemnification limits that are set out here, including a threshold, which is a minimum threshold or a deductible or a maximum cap. There will be a process that is laid out in the indemnification clause, which the parties will need to follow in order to make a successful indemnity claim under the document, the manner in which third-party claims have to be handled, etc. The indemnification provision will also require parties to talk about the extent to which this is the exclusive monetary remedy that is available to the buyer, or is this just one of many remedies that the buyer may exercise. This also becomes, again, one of those topics that is discussed a lot at the time of negotiations. The manner in which seller's knowledge or the buyer's knowledge will come into play at the time of making indemnity claims also becomes important to discuss and include in the document. Moving on is just a quick recap of all the discussions we've had so far. The key headline items that you can see on your screen here are: when dealing in an asset sale transaction, be as descriptive as possible. It's extremely important to identify the right parties and to identify the assets and liabilities that are being acquired and those that are considered to be contractually excluded. An asset purchase transaction does not involve an automatic transfer. Every asset that you buy will need to be transferred separately, and therefore planning and pre-planning is key. As we discussed at the time of the conditions precedent and closing, every single asset class will have to have its own process for transfer, and this will need to be clearly identified and worked on as part of the conditions precedent section. Deal certainty is of course important to both parties, so it's important to look at the asset purchase agreement in light of that and include termination or walkaway rights specifically in the context of whether the purchaser would want to walk away between the time period of signing and closing. Risk allocation and clear understanding of the assumed and excluded liabilities is certainly one of the most important features of the asset purchase agreement. And it's important to look at this closely and to ensure that this mirrors the commercial understanding as closely as possible. And the last one to think about in the context of an asset purchase transaction is the transition of the shared services agreement. As we discussed, if the buyer will have some dependency on the seller post the closing as well, then this agreement becomes extremely important and should be agreed and executed as part of the conditions precedent clause. I'll stop here for now and see if we have any questions, but I hope you've enjoyed the presentation. Over to you, Samir.
Thank you very much, Nidhi. That was excellent. And when you say some questions, I think our chat box is running out of space. So we really have tons and tons of questions, and which is incredible. Thank you very much, ladies and gentlemen. Your participation is what keeps this alive. So let's just straight dive into some of the questions, and Nidhi, please take these as you go. So a very basic question somebody has asked: how do you explain the difference between an asset transfer and a business transfer?
Right. So in an asset transfer, like we discussed, the ability there's buyer has the flexibility to cherry pick the assets and liabilities that it wishes to acquire. In a business transfer, on the other hand, you have to acquire the business or that particular business vertical on a going concern basis as a slump sale. So you won't be able to cherry pick components of that business that you want to acquire or liabilities that you wish to not acquire. So that is one of the key differences between the two. Another one, and an important one, is the risk associated of successor liability in case of an asset sale and a business transfer. The risk of successor liability is lower in an asset sale transaction because the parties do understand that you have become the owner of some select assets and liabilities and not necessarily of that business. However, in case of a business transfer, the risk of successor liability is potentially higher, especially when one talks about direct tax claims of the seller and also labor laws in India, because there is enough jurisprudence in India to suggest that the owner of a business can be considered to be jointly and severally liable for some labor law dues of the seller. So these are the two important elements to keep in mind when you're deciding whether an asset purchase or a business transfer is the right way forward for your deal.
Interesting. I think, and I can see a bulk of questions on the tax treatment of an asset transfer versus a business transfer. And as we discussed, ladies and gentlemen, we'll have our colleagues and partners talk through some of the tax issues. So perhaps we park that. Now, going back to where you started, Nidhi, you spoke about that, but the buyer must be an Indian entity. So there are a few different questions on that. So let's start with probably the preliminary ones. There's a question here: why does the buyer entity have to be an Indian entity?
Yeah, that's an interesting question and one that we get all the time when we're dealing with an asset purchase agreement. So essentially, the way this works is the question you're really asking is, can a foreign company acquire assets in an asset purchase? So a foreign company who wants to act as a buyer will have two options. They can either drop down a subsidiary in India, and or they can undertake this through a branch office. Of course, whether a branch office is ideal or not from a tax perspective, I won't get into. But essentially, these are the two ways in which you will need to, as a foreign company, acquire assets through an Indian entity. An example is if you are, as part of this transaction, looking to acquire immovable property, then there are restrictions around a foreign company acquiring immovable property that is located in India. So that is one of the legal impediments or restrictions from you being able to actually consummate this transaction, because law will not, in fact, allow you to become owner of that immovable property as a foreign company. So you therefore see that foreign companies will drop down a subsidiary in India or use an associate company that's available within their group structure. And that is the entity that will actually go ahead and consummate the asset purchase agreement in India.
Okay, so now let's assume we walked over to an Indian company. There's a question on any peculiarities. So there are actually 3 or 4 different questions on foreign investment, and in particular, a foreign owned and controlled company. So there's a question: can the buyer be a foreign owned and controlled company for an asset purchase of an Indian entity? And are there any implications from an FDI perspective?
That's a very interesting question again. Thanks for asking that. I think so the way a foreign owned and controlled company and the restrictions under the FDI policy are set up, they're mostly completely geared towards share sale transactions. The way those provisions are set up today in the policy don't talk about an asset sale by a foreign owned and controlled company. Having said that, let's take a real life example. You have an IT company that is going to tomorrow maybe go ahead and buy some defense assets. Today you could have an IT company that is completely foreign owned and controlled, because that is in fact permissible as per the exchange control laws. But tomorrow, when this IT company, which is an Indian company, goes ahead and transacts for an asset sale transaction with another Indian company to in fact purchase defense assets, there's nothing today in the law which will stop that from happening, that particular asset sale transaction. But what is that IT company going to do with those defense assets? If it then in fact is going to use it in such a manner that becomes a regulated business activity as per the applicable foreign exchange requirements, then of course that will become a challenge, because you're now sitting on maybe 100% FDI and trying to undertake an activity where 100% FDI is not permitted. So I guess you'll have to wear two hats while answering that question, which is there are two phases of this transaction. Maybe when you are transacting in the asset sale leg of that transaction, being an FOCC or the sector in which you operate may not be most relevant, but what you choose to do with those assets once you've acquired them, and if you in fact shift gears and start operating in an asset in a sector which is otherwise regulated, then yes, those conditionalities are as relevant.
Superb. So you spoke of an IT company. I have a question from somebody who seems to be from an IT company. When you're transferring a business, do you need employee consent for sure, or is that something which can be waived? I guess they're basically concerned about transfer of employees and the consent requirement.
That's right. So there are two things here. The law protects a certain category of employees when such a transfer is taking place. So law in India today will suggest that if you have certain blue collar employees or employees who are termed as workmen, then those workmen are protected. So if you don't, if you retrench them when this transfer is happening and you don't in fact give them continuity of service, etc., then there are legal consequences of not in fact transferring them with their consent. Of course, if we talk about employees who are not workmen, then the law does not mandate you to seek their consent, but the contract in all likelihood would, because the contract that you would have executed with those employees will say that the employee is employed with ABC company, which is the seller. You can't, without their consent, simply ask them to now work for XYZ company because there's no privity of contract with that entity either. And employment is, of course, something which is personal to the employee and the employer in question, and therefore they will both need to agree if this employment entity has to change.
Interesting. So on consent, there are about 3 or 4 different questions on transfer of liabilities, and in particular, let's say third-party liabilities like lenders, suppliers, and customers. If consent is not obtained, would the seller continue to remain liable for the third-party liabilities, or would the buyer still assume those liabilities?
What liabilities are we talking about?
Lenders, suppliers, creditors. There are about 4 or 5 different questions around this.
Sure. So let's take the example of a lender to make the response more specific. Yeah. So if we're talking about a lender today who sits on the books of the seller, in all likelihood, if the seller has to transfer material assets to the buyer, then the consent of that lender will need to be procured, failing which it may result in a material breach or an event of default under the financing documents that have been executed by the seller. What this means is, let's take that forward. The seller has actually sold these assets to the buyer without seeking this lender's consent. Then the lender has the ability to exercise the remedies that are available to the lender under its own financing documents. That is not to say that it can make this transfer void, but it can certainly go after the seller and exercise all the remedies that are available. It may be prepayment, it may be reconstitution of the board, it could be enforcement of all the other security package that has been given to the seller. So the lender can choose to do any of those.
Perfect. So now moving on to just on coming back to that foreign entity point, there's a question here. You mentioned that a foreign entity can't purchase Indian assets. What if there are registered trademarks and patents? Is that something which a foreign entity can purchase?
Yes. A foreign entity can in fact purchase intellectual property in India. You can also be the owner of that intellectual property as per the records of the registry, or the will need to be filed. And in fact, there are several examples of this having occurred as well.
Now, there are at least 5 or 6 questions, and this was something which we discussed in the SPA session as well. Non-competes in particular, and how non-competes work in a BTS scenario. Are they enforceable, not enforceable? What should really happen to make it enforceable? Again, I'm just trying to bunch a few questions together in the interest of time.
Yeah, no, that's a very, very Interesting question. Non-competes have obviously been one of those clauses that every buyer wants to include in the document and make sure that the seller is not doing anything cheeky after the closing of the transaction. Unfortunately, there's no one-size-fits-all response to this question. However, generally speaking, non-compete clauses are enforceable in a business transfer or an asset purchase transfer. And courts have in fact recognized that, in such instances also, non-compete would not be considered to be a contravention of Section 27 of the Indian Contract Act, which essentially, is the basis on which all these non-compete clauses are tested to see if the non-compete clause went too far in restraint of trade and therefore should not be enforceable. In fact, one such decision that comes to mind right now was that of the Kohinoor Specialty Foods case, where the Delhi High Court essentially discussed all the prominent principles with respect to the non-compete enforcement. And that was in fact a case where there was a business transfer agreement between the parties, which included a non-compete clause, and the court in that case upheld the enforceability of that non-compete clause. So I would say, generally speaking, they're enforceable. Obviously, the principles that apply to enforcement of non-compete clauses, whether in a BTA scenario or otherwise, such as reasonableness of the restrictions, etc., those would continue to be relevant. But if you're ticking all those boxes, non-compete clauses have been considered to be enforceable in asset purchase or business purchase transactions.
Great. Somebody said you spoke of IP. What are the other kinds of intangible assets that you could transfer through an APA or a BTA?
There could be goodwill, which you often see as one of those intangibles that are transferred. In fact, transfer of goodwill is also extremely important from several perspectives and lenses. This is extremely important even for the non-compete, in fact, that we just spoke about, because if goodwill as an intangible is being transferred as part of the asset purchase agreement, then it makes the non-compete that much more robust and enforceable. It's also relevant from an IP assignment perspective, because if you are not transferring from a trademark perspective, not transferring the goodwill along with that trademark, then that assignment of trademark is not considered to be whole or complete. So yes, I think goodwill is an important one to bear in mind.
We've received something on data. Can you transfer counterparty data or third-party data as a part of an APA?
Yes, you can. Of course, the rules under the Information Technology Act and the privacy rules will need to be complied with. You have to ensure that the customer data, as an example, that you want to transfer, you sought consent from the customers whose data you are looking to transfer, etc. The party who is acquiring will have to have the same level of data protection and security measures as the seller entity. So there are certain protection measures that are built into the law, which will need to be adhered to. But if those are complied with, then customer data can in fact be transferred.
Okay, so now just moving in terms of transfer, there are a few different questions I'll try and weave together. There are obviously some people I can see from the manufacturing side who are a little concerned about the transfer of environmental licenses. And they're saying it sometimes takes forever to get a license up and running. There's an interesting question on how you can use a scheme of arrangement to bridge the gap between transferability of licenses. Do you want to talk about that a little bit?
Sure. So conceptually, the big advantage of a scheme of arrangement in any scenario is that all the transfer will happen by virtue of operation of law, and not necessarily as per the different contracts or everything else that we just mentioned. So that's a big advantage, and oftentimes that's the reason why a scheme of arrangement is even preferred, because you don't need to rely on consents, so as to speak of counterparties like customers, etc. And even in relation to licenses, it's extremely important. It helps that there is a scheme of arrangement which has approved this transfer, and therefore it goes a long way when you're trying to establish the transition of licenses from one entity to another. But it would be amiss on my part to not mention the timelines that are also relevant from a scheme of arrangement perspective. Depending on which tribunal you have filed the scheme before and all of that, there could be, depending on how busy that bench is, you're looking at anywhere between 6 to 8 months to actually get that approval for a scheme of arrangement, and it requires a lot of work before you actually go ahead and file that scheme. So there is a time lag there as well. So I think on an overall scheme of things, you're looking at about a year in timelines to get that scheme of arrangement approved. But yeah, so whether you want to sort of go down the path of a scheme of arrangement or do this asset purchase transaction will obviously be a function of what is the commercial intent of the transaction. Sometimes the deal timelines are not that relevant, and other considerations will outweigh the time period in question.
Okay, I'm conscious of time, so we'll probably take our last three. In terms of regulatory approval, somebody has come up with a question on CCI. So is CCI approval required in case of asset purchase agreement? If not, then is it advisable to do a check whether the transaction otherwise needs approval under any of the other Competition Act provisions? This is from somebody in the pharmaceutical manufacturing space.
Okay, got it. Yeah, thanks. Yes, it's important to undertake the analysis on whether, in fact, an antitrust approval will be required. The way the thresholds are set out today under the Act will apply even to an asset sale transaction. But the sort of good news is that a few years ago, the law was amended. And now when we are considering whether the threshold, the assets that you are acquiring or the business that you are acquiring meet the required thresholds for which a CCI approval will be required, the thresholds are only tested against the value of the assets or the business being acquired in question, and not against the entire entity that actually owns that asset. So to take an example, if L&T is the seller and L&T is trying to sell some non-core assets to a buyer, you will not need to look at whether L&T as a whole meets those numbers that are set out under the CCI Act, because in all likelihood it would, but maybe those non-core assets are not that material or significant in terms of value. And therefore, now the law allows you to only look at the value of the assets and the business you're transferring and not of the seller entity as a whole.
Okay, interesting. Right now, just in terms of common market practice to secure indemnities, and how do you ensure that the seller actually has something left to pay and the seller hasn't siphoned off all the funds? Or deferred consideration. Again, there's another question on generally bundling deferred consideration and post-closing recourse.
Got it. So deferred consideration is obviously one way in which you as buyer can sort of structure the transaction to say that this will be that some part of the consideration will only be paid later when maybe an indemnity time period has lapsed, so that you also have some as buyer, you have something to hold on to and you're not completely exposed to the whims and fancies of the seller in that sense. But deferred consideration and asset sale should be considered closely, only because again of the way the law for specific things is set out in India. So as an example, if in an asset sale transaction you are as buyer looking to acquire immovable property from the seller, then there is in fact a provision in the Transfer of Property Act which says that if you as seller have not got the full amount of the purchase money, but you have transferred the immovable property to the buyer, then in fact the seller has a charge on that property to the extent of the unpaid purchase consideration amount. So it's important to keep in mind that, you know, when you are negotiating a deferred consideration clause in an asset purchase agreement, there are certain provisions in legislations in India which should be borne in mind, and the transaction documents should specifically carve out any such charge in the hands of the seller.
Sure. I think we're running out of time, but we'll definitely come back to you, ladies and gentlemen. One of the questions was, will you be sending us your slide deck? Definitely, we will do so. So with that, we come to an end to the Q&A. Now, of course, before concluding, we will request you to take an audience poll. We take this very seriously as a part of our continuous improvement of this program. Mitesh, please start the poll. You will also separately receive a request for your feedback on the webinar. Please do take the time to send us your feedback. Compliments, comments, criticism, everything is welcome. The form is designed to take less than a minute to complete. Thank you very much to everybody who participated in the poll. It has certainly been a very thought-provoking discussion. And to me, some of the key takeaways from today's webinar were how the number of laws that apply to the sale of a business or a grouping of assets are significantly higher than a vanilla share purchase. Nidhi spoke of the Transfer of Property Act, the Information Technology Act, employee legislation, income tax laws, and the absolute gamut of the universe. While this presents structuring opportunities, this also presents transactional challenges. And not to forget, for the buyer, the seller, several third parties, customers, employees, suppliers, the entire ecosystem, it defines their legal liabilities and obligations going forward. Therefore, one cannot emphasize enough the importance to identify these opportunities and challenges in advance and suitably discuss those with capable counsel to solve them before they become a problem. And this applies equally, ladies and gentlemen, to a buyer and a seller. So finally, I would like to thank Nidhi for such a lucid and comprehensive presentation, and also our audience for your attention and your overwhelming participation as always. I hope you found the webinar interesting and a worthwhile investment of your time. We certainly enjoyed bringing it to you, and please do not hesitate to contact us regarding any matters arising from this webinar. Our contact information is on the contact slide at the end of this presentation. Thank you again for your attendance, and we look forward to being of service again in future webinars. Thank you and have a lovely day.